Good morning, ladies and gentlemen, distinguished guests, respected speakers, and the fellow participants. Welcome to the International Conference on Law and Governance, the icLave 2025, hosted by the Faculty of Law, Universitas Indonesia. We are deeply honored to have you all here joining us for this 2 days conference with the inspiring theme, Disruption in Legal Governance, Rethinking the Concept of Sustainability, Development, and Democracy. My name is Handayani Primandiri, and it's all my pleasure and my honor to serve you as the Master of Ceremony for today's session. On behalf of the organizing committee, we would like to express our warmest regards to our distinguished speakers, honorable deans and professors, international delegates, students, and participants that joining us across the globe, both sides, online, and also offline in here. We are truly delighted to have you all here engaged in the meaningful discussion about how disruptions continues to shape our future of law, governance, and democracy in this modern world. In the icLave 2025 provides the valuable platforms for the scholars, practitioners, and also the policymakers to exchange the ideas and explore the innovative approaches in addressing the challenge of our time. Over the next 2 days, we will listen to the insightful presentations from the leading experts, engage in the thoughtful, provoking panel discussion, and also exchange the research finding and perspective. Through this session, we aim to deepen our understanding of the evolving dynamics of law and governance in this era of disruption. Ladies and gentlemen, to begin our ceremony, please stand and joining us in singing our national anthem, Indonesia Raya. Please raise for all the participants. Thank you. Please have a seat. And to bless our event and express gratitude for this meaningful occasion, let us continue with the prayer session. And the prayer session will be led by Bapak Muhammad Rifai. Please welcome.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera untuk kita semua. Hadirin Bapak Ibu para tamu undangan yang berbahagia, untuk mengawali acara pada pagi hari ini, marilah kita sama-sama buka dengan pembacaan doa, dengan harapan mudah-mudahan rangkaian acara pada pagi hari ini sampai siang sore nanti berjalan dengan lancar, hikmat, dan bersahabat. Kepada Bapak Ibu yang beragama non-Muslim, kami mohon berdoa menurut keyakinan dan kepercayaan Bapak Ibu masing-masing. A'udzubillahi minasyaitonirrajim. Bismillahirrahmanirrahim. Allahumma sholli ala sayyidina Muhammad wa ala ali sayyidina Muhammad. Alhamdulillahi rabbil alamin. Allahumma ij'al jama'ana hadha jama'an marhuma wa tafarruqana min ba'dihi tafarruqan ma'suma. Wala taj'al fina wala minna saqiyan wala mahruman. Ya Allah, Tuhan yang Maha Pengasih dan Maha Penyayang, kami mohon rahmat dan kasih sayang-Mu sehingga segala aktivitas kami dalam acara ini berjalan dengan lancar, khidmat dan bersahabat. Pada pagi hari ini kami berkumpul di tempat ini. Kami manjatkan puji syukur kepadamu sekaligus membuka kegiatan kami. Ya Allah, berkahilah segala aktivitas kami selama dalam mengikuti rangkaian acara ini dan jadikanlah sebagai amal ibadah di sisi-Mu. Untuk itu ya Allah, tetapkanlah rahmat dan kasih sayang-Mu kepada kami dan jadikanlah pertemuan ini sebagai pertemuan yang Engkau ridhoi. Allahumma la sahla illa ma ja'altahu sahla. Ya Allah, mudahkanlah segala urusan kami karena tidak ada yang mudah kecuali Engkau jadikan mudah. Ya Allah, bukakanlah atas kami pintu kebajikan, pintu berkah, pintu rahmat, pintu kekuatan, pintu rizki, pintu kesehatan, dan pintu keselamatan. Karena hanya Engkaulah yang Maha Pengasih dan Maha Penyayang. Ya Allah, ya Tuhan kami mohon berikanlah kepada kami kedewasaan kehidupan berpolitik, berdemokrasi, dan kemudahan dalam percepatan pemulihan ekonomi nasional, agar tercipta bangsa yang bersatu, aman, adil dan sejahtera, dan hindarkanlah bangsa kami dari fitnah dan mara bahaya. Mantapkanlah tekad kami untuk membangun bangsa dan negara kami, agar menjadi bangsa yang beriman, bertakwa, berakhlak mulia, makmur, dan sejahtera. Rabbana afriq alaina sabra wa thabbit aqdamana. Ya Allah, curahkanlah kesabaran atas kami, dan teguhkanlah pendirian kami terhadap cobaan dan kebenaran. Ya Allah, berkahilah semua ilmu yang kami dapat selama kegiatan ini, sehingga kami dapat mengamalkan setelah kami menyelesaikan rangkaian acara ini. Dan jadikanlah kami menjadi suri tauladan dalam keluarga, masyarakat, bangsa, dan negara. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Walhamdulillahi rabbil alamin. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Marifai, for leading us into the prayer. Ladies and gentlemen, before we proceed to next agenda, let us enjoy a special cultural performance presented by Liga Tari Universitas Indonesia. Today, they will perform the Tari Saman, one of the Indonesian's iconic traditional dances originating from the Gayo ethnic group in Aceh province. Please welcome Liga Tari Universitas Indonesia.
Hai bintang Ya huwallah huwallah ehad. Hai meputih putih, putih lah si bungong putih. Hai lelat lomba binte, lomba binte lah ke ayam mata. Hai meselam selawatnya, hatelan pede. Hai nyobaro pule, oh lemah gata yahu. Hai meputih, putih si bungong putih. Hai lelat lomba binte lah ke ayam mata yahu. Wallah eha, ala eha lahu. Ya huwallah eha. Hai mau putih si bungong putih. Hai lelat lomba binte lah ke ayam mata ya wallah eha, ala eha lahu. Laho tujang Indonesia nang roruntuhan letak di sinan Pulau Cutraya, hai Cutraya Indonesia. Dari hai Sabang sampo Merauke, Mehato sabe bakutiara laho tujan. Hijau padebang guhang hijau me rentang lekat teripahai metujo lapai awan me rentang lemabu bayang sinjawas nyawa muka laho tujan. Metajak ubang tajako pada tengoro mare di ronde rusahai melondo londong imata hile teingat sabe ulan nganon gata laho tujan. Hai la ilala he. Tajak ugle, tajak kokaye, tinggai peredai tempat lan kutru. Mebene beberakan yang dile, jampang nelake rano sigapu. Taja ugle, taja kokaye, tinggai perenai tempat lan kutru. Hai la ilala he, wasian he inhala matua la ilala he. Hai jala. Lan buruk menari lanate renggunong lembah cabang bungong hai anak elek tuan hai jala. Lan buruk menari lanate renggunong lembah cabang bungong hai anak elek tuan hai jala. Lan burung menari lan teh renggunong lembah cabang bungong hai anak elek tuan hai jala tun mile la mile jala tun hai jala tun mile la mile jala tun ku tiding lahang ding ham hai meputih putih hai meputih putih la putih si bungong putih la putih si bungong putih hai lenlat babinte hai lenlat babinte la binte ke ayam mata la binte ke ayam mata ha hai maselawatnya lawatnya hatalan pedeh lawatnya hatalan pedeh hai nyobaro pule la pule olah magata ha hai meputih la putih si bungong putih la putih si bungong putih hai lenlat babinte la binte ke ayam mata aku tering lahang ding ham lah hembot bot lah hati ding Haila otsa lan parahu raya bungkau cabang kapatah tiang tamengku alahai dicut bang kase di ulan sayang na nyumbe ulan lengan ngan gata lan parahu raya bungkau cabang kapatah tiang tamengku alahai cubang kase di ulan sayang na nyumbe ulan lengan ngan gata helosa ilang mama alan kapadi eta bura bacute salah musa alan salamun apun hawedi kita lamparahu raya bukau cabang kapatah tiang tamengku ala di cubang gasaya di ulan sayang na nyumpe ulan ngan kata laut sah Hey tu jala he tiding ala hiding wajah eha hey tu jala he tiding ala hiding wajah eha Allah.
Thank you very much to Liga Tari Universitas Indonesia for wonderful performance of Tari Saman. It's giving us a little bit goosebumps, isn't it? Okay. Ladies and gentlemen, and now to officially begin our conference, it is my honor to invite Dr. Parulian Paidi Aritonang SH LLM MPP, Dean of Faculty of Law, Universitas Indonesia, to deliver his welcoming remarks. Please welcome Dr. Parulian Paidi Aritonang.
Thank you, Handayani. Assalamualaikum warahmatullahi wabarakatuh. Good morning, distinguished guests, colleagues, and friends. It's my great pleasure to welcome all of you to the 7th International Conference of Law and Governance in a Global Context 2025. On behalf of the Faculty of Law, Universitas Indonesia, I extend my warm regard and greetings and sincere appreciation for your presence, both in person or virtually. This year's themes, Disruptions in Legal and Governance, Rethinking the Concept of Sustainability, Development, and Democracy, is very timely and relevant. Around the world, we are facing major disruptions, environmental challenges, digital transformations, economic shifts, and political change. These disruptions affect how we understand the rule of law, how we govern society, and how we ensure that development remains sustainable and democratic. This conference aims to provide a platform for academics, practitioners, policymakers, and students to share ideas and experience. It's our belief that dialogue among these groups is essential to find balanced and innovative legal solutions to today's global problems. Over the next 2 days, we will hear from distinguished speakers, panelists, who will share their insight on topics such as climate justice, corporate governance, democracy, and the futures of legal education. I'm confident that this exchange of the idea will strengthen our understanding and inspire new collaborations across countries and disciplines. I would like to express my sincere gratitude to all speakers, presenters, and participants for their valuable contribution. My special thanks go to the organizing committee led by Dr. Prika and friends and students volunteer who have worked hard to make this event possible. I hope that the 7th icLave will not only enrich our academics' perspective, but also encourage us to take concrete steps in building fairer, more inclusive, and sustainable legal system for the futures. Thank you very much, and I wish you a productive and inspiring conference. Assalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Bapak Dr. Parulian Paidi Aritona, our Dean. Ladies and gentlemen, before we continue to the next agenda, I would like to invite all speakers, distinguished guests, and also the participants to come forward to the centers to take a photo session, a group photo session. Please, we will help by our photographers. And the photographers will take the picture from here, from the stage. So please, ladies and gentlemen, we step aside and also move forward. Please move forward to the side, more center. Yeah, Bapak Ibu, please just move closer to the center, please. Okay. Okay. I will be counting in 3, 2, 1. Okay, next. 1, 2, 3. Yeah. Okay, oh, Okay. Another device, yeah. Please, 3, 2, 1. Okay, thank you so much. Please have a seat. And now as we move forward, we will begin the keynote session, plenary session 1 of the icLave Conference 2025. And in this session, we'll explore one of the central themes of our conference regarding the current situation of environmental law in theory and practice. And for this session, it will be led by our moderator, Zevanya Albrena Sembiring, SH-LLM. Zevanya Albrena Sembiring is a lecturer of the Faculty of Law, Universitas Indonesia, and researcher at the Center of Environmental Law and Climate Justice. He received the Bachelor of Law from Universitas Indonesia and a Master of Law in European Law with concentration on Law and Sustainability from Utrecht University, Netherlands. Therefore, I'm pleased to hand over the floor to Zevanya Albrena to lead the discussion. Please welcome Zevanya Albrena Sembiring.
Many thanks to the Master of Ceremony for your kind introduction. Ladies and gentlemen, distinguished guests, esteemed professors, students, and all participants, it is my pleasure to welcome you to the first plenary session of the International Conference on Law and Governance 2025. In this opening plenary session, we will address one of the most pressing issues, challenges of our time, the state of environmental law. Environmental problems such as climate change, pollution, and biodiversity loss continue to threaten our collective well-being and test the effectiveness of our legal systems around the world. The key questions we ask today are: how effective is our environmental law in responding to these growing challenges? And to what extent does it truly influence the quality of our environment? With that in mind, the first plenary session carries the theme of current situation of environmental law in theory and practice. To explore this topic, we're joined by distinguished scholars who have devoted their academic lives to the study and advancement of environmental law and governance. And let me introduce you to our first speaker. Our first speaker is Professor Michael Faure. So I'll try to read his short biography. Professor Faure is a professor at Maastricht University, specializing in comparative and international environmental law, including environmental criminal law, tort law, insurance law, and economic analysis of action law. He also serves as an adjunct professor at the Faculty of Law, Universitas Indonesia. In addition to his numerous academic roles, he has been instrumental in advancing interdisciplinary approach that bridge law and economics. Unfortunately, Professor Faure could not join us in person today. However, he has kindly prepared a recorded presentation for us. In his presentation, he will discuss the effectiveness of environmental law in the face of the Anthropocene epoch. Ladies and gentlemen, please join me in welcoming Professor Michael Faure. Let's give him a warm round of applause.
Good morning to all of you in Indonesia. I'm very happy to have the opportunity to talk at this icLave conference Of course, I do regret not being able to be there in person. Some of you might remember that in the beginning of September, I was approximately 2 weeks in Jakarta, enjoyed very much the teaching and the contacts with many of you. But then I even left many things in Jakarta, assuming 2 weeks later I would be back for the icLave conference. But then unfortunately, given the events that took place, it had to be postponed, which of course I fully understand. I want to express my gratitude to Choki for organizing this wonderful event and for involving me here. And of course, to Professor Andri for arranging all of this. I am very happy to have this opportunity to say a few words. When you will be talking, it will be 4 a.m. in the morning for me, so it was not possible to participate live. But I'm very happy to talk in this session on the current situation of environmental law in theory and practice. And indeed, I would like, regarding this topic of what is the current state of environmental law, I would like to elaborate on 5 different points briefly. And those points that I would like to discuss are the following. There is a first one when you talk about the state of environmental law, which goes to my heart and which is the following. I think that environmental law has been very effective. Let me explain why I state this. Sometimes I come across colleagues, and the colleagues look around and they see, of course, the depressing state of the environment. They say we are living in an Anthropocene. They say that we have to move to a radical change towards awarding, for example, rights, human rights, environmental rights, property rights to nature or to ecosystems, as otherwise the current law, the current environmental law is not able to protect the environment. And of course, they are right to the extent that if you look around you, you definitely see several planetary crises. We see a climate change crisis, we see a pollution crisis, and we see an enormous loss of biodiversity as well. That is absolutely true. However, what I feel is dangerous and also not correct is to deduce from the current state of the crisis that environmental law would not be effective. To the contrary, dear colleagues, dear friends, I think it is quite important that if you look at the empirical evidence, and there has been a wonderful book that was published many years ago, I think in 1996, by DeWeese, Duff and Trebelko. So it's an old book, almost 30 years old, and the book is called Exploring the Domain of Accident Law. And what do? For a variety of domains, not only environmental law, also medical malpractice, also traffic accidents, occupational health and safety, they look at what is the theory predicting us and what have we seen in practice. And then there is something quite interesting that they conclude, and that's why I mention it here. If you look at the situation of the environment then, talking 1996, they mention that in fact in North America, the US, Canada, but also in Europe, the state of the environment 20 years earlier, so in the 1970s, was much worse than it was in the 1990s. In other words, there have been spectacular increases in environmental quality over 20 years, and they subsequently analyze to what was this due, and their main answer is to environmental regulation, in other words, to environmental law. Showing, in other words, that environmental law instruments have been effective in improving environmental quality. Little detail, they have a summary of several studies. One of the studies that they do mention is related to the effectiveness of environmental charges and environmental taxation, for example, in a country like the Netherlands. And they show that as a result of introduction of charges, taxes on emissions into surface waters, that in fact the pollution of the surface waters has reduced by 50%. The result, ladies and gentlemen, is that we notice that in fact in the 1990s the environment was, and it's not only true for the water pollution, but also as far as air and soil is concerned, in the 1990s environmental quality was better than in the 1970s. Does that mean that I say that there is no problem? Of course not. I do see that there is many problems, and of course question is always, is the glass half empty or is the glass half full? And my point would be, the answer to the many planetary crises that we are confronted with is definitely not that environmental law would not be effective. No, environmental law has been very effective, and that is a message that I think we should also get across to the young people who sometimes look a bit depressed, understandably, if they look at the state of the environment. And our answer, according to me, should be that we only need more and better environmental law, and moreover, that's a point that I will talk about at the end, we also need more and better enforcement. Now, you talk here about a session on structure of environmental law, theory and practice. As far as theory is concerned, we of course know how it comes that environmental law has been relatively effective, and this has a lot to do with a phenomenon that we call the environmental Kuznets curve. What does that curve teach us? That teaches, in fact, that there is a relationship between environmental pollution and economic growth. What most countries experience is that in the beginning of economic development, pollution will increase, which is normal. Start of your industrial evolution, you will observe more pollution. But then it looks something like an inverted U-curve, whereby every time more pollution, but then at some moment the pollution will be decreasing at the top of the U-curve. In other words, you get more gross domestic product, more economic growth, but your pollution levels decrease. There is a couple of reasons for that. One of them is that technological innovation may make it possible that you abate pollution at lower cost. Also, the demands of the citizens, once the basic needs have been satisfied, also are demands for a higher environmental protection. Now, this environmental Kuznets curve has also been tested empirically, and people have in fact discovered, yes, that those countries that have stringent environmental regulation, that those countries also have a good economic prosperity, and that they see a reduction of environmental pollution as well. Now, that is quite an important point, because what it indicates is that this reduction of environmental pollution does not come automatically. So you cannot assume the more that you simply develop economically, that automatically you will have a cleaner environment. No, there is nothing automatic. But what happens is that when countries start developing economically, their regulation improves. They start respecting the rule of law, the infrastructure and the quality of the institutions improves, and it is, in other words, the quality of environmental law that helps reaching higher levels of environmental quality as well. And I think that that is an important lesson also for countries in the global south. You should not be afraid of environmental law. In other words, environmental law does not automatically lead to more costs. Environmental law can also lead to a situation where your companies become more competitive and make higher profits. Of course, some of you will immediately recognize that what I am referring to here as well is the work of Michael Porter from Harvard. Porter had a story which later became known as the Porter hypothesis. What Porter was basically saying is that if you have stringent environmental law, what we see is that much heavier obligations are put on industry. In order to be able to comply, industry needs to do investments in new technologies, innovation in other words. And what is so nice? The innovation leads then to compliance with environmental law, in other words, also to higher environmental quality, but the innovation also improves the way in which the business is running. In other words, the innovation also leads to increased profitability. This is what we sometimes call doing well by doing good. And if you look at countries, one of the best examples, or states, is California, where California had very stringent environmental legislation, yet at the same time had very high profits. Look at Silicon Valley, one of the most prosperous areas in the world. And that is something that sometimes is called now the California effect, whereby California was leading and able to impose their standards on other countries as well. I often say, when I'm talking, for example, to civil servants that need to do enforcement, and they look sometimes a bit depressed at me and say, Michael, when we come to industry size, and industry says, we are not able to do many investments and to have high costs because it will lead us to a reduction in our competitive position, I always answer to them, point them to the Porter hypothesis. The Porter hypothesis indicates that if they do well environmentally by complying with environmental law, they will do an innovation. For example, they change their production technology, they move to clean production technology, which will also lead to more profitability. I think that that is an important lesson that we should also tell our industry. Now, ladies and gentlemen, you implicitly heard already a third point that I wanted to stress here. When we look at the state of the environment and on the effectiveness of environmental law, what I find absolutely crucial is that we engage also as environmental lawyers much more with empirical studies. Let me say that when I started back in the Stone Age with environmental law, end of the 1980s, almost 40 years ago, we did not have the possibilities of doing serious empirical work like we have it today. Today, with the new techniques, we are able to do serious empirical studies whereby the relationship between particular environmental instruments, emission trading, environmental taxes, environmental liability, and environmental quality can be indicated. And I think also for countries like Indonesia, it is absolutely crucial that we engage in this type of empirical work. Why? This empirical work allows us to do what we call evidence-based environmental regulation. In other words, we can look at what are the instruments that are the most effective in protecting the environment. We base, in other words, our regulation, our environmental law, on empirical work, on evidence. And this, ladies and gentlemen, is, according to me, the key for the future, that we should look much better at which instruments have really worked. Where did we see that industry reacted and that there was more and better compliance and higher environmental quality? We should do evidence-based learning and implement that in new instruments. That is certainly also the case for a fourth topic I wanted to address briefly, the topic being enforcement. What I think is the crucial issue for the years, maybe the decades to come, is the issue of enforcement. So far, I think we have developed quite a good environmental law. And even if I look at developing countries, and I look also at Indonesia, I see that a country like Indonesia has good quality environmental law and regulation. very often there is not a problem. Where the problem really lies is in its enforcement. And of course, there we need to learn from theory, but also from practice in order to improve enforcement of environmental law. You know that we classically have two different models. On the one hand, we have a deterrence model, where through stringent instruments like criminal law, we try to deter environmental crime from occurring. On the other hand, we have compliance models, where we say the most important is that we look at how we can bring companies towards compliance with environmental regulation. Now, as far as deterrence is concerned, we know that the deterrence depends in fact on three separate elements. First of all, you have of course the probability of detection. How do you make it likely that companies are detected when they violate environmental regulation and commit environmental crime? Now there already a lot can be done by increasing effectiveness of inspections. We now use what we call smart enforcement methodologies. In other words, we do risk-based enforcement, where we look where are the likelihoods of infringements the highest and where might there be relatively high damage. And we focus enforcement efforts there. And we also look, after we have seen violations, especially at those companies where the violations were more frequent and more serious. In other words, smart enforcement can help us increase the probability of detection. But a second element in deterrence is, of course, if you have intentional violators that had lots of benefits with violations, that raised high profits by violating environmental law, then the answer is, of course, that we need serious deterrent sanctions on the corporation, eventually serious fines, but we might also have to combine it with prison sanctions for directors and officers that intentionally violated environmental regulation and thereby contributed to pollution. But there is a third element, crucial in deterrence. Next to a high probability and a high sanction, there is also the element called celerity. What do we mean with celerity? That is the speed of imposition of the sanction. If you really wish to reach deterrence, don't come with a sanction 20 years later. But then the procedure should be of such a nature that it is efficient, quick, and that we can have a rapid response in order to generate a good reaction and more prevention and deterrence. Of course, I talked about criminal law as a method of deterrence. In some cases, you might also want to need administrative sanctions that can equally be efficient. What is, however, a crucial point, also for developing countries, is that all the law enforcement authorities guarantee that they are independent, that they work in the public interest, that the executive authority, the government, let the administrative authorities work in full independence, that the way in which they work is transparent, and of course that they are accountable. Otherwise, there is a big danger that private interest will prevail, and there is a danger that powerful interest groups from industry might capture the enforcement authorities, and that enforcement will become weak and fail altogether. I come, ladies and gentlemen, to the end of my story with a fifth and final point, and that goes to the North-South relationship. I talk here from my home in Belgium, in Europe, and although I do wear the batik shirt that I received in Jakarta last August, I know that I am far away from the problems that you are confronted with in Indonesia. I find it crucial that in Europe, not only in Europe, but in northern countries in general, that we do realize that there are serious problems with countries in the south in enforcement, again, of environmental law. What I find crucial is that we work on a cooperation, coordination, whereby from the north we provide assistance based on a demand from countries in the south, and that we try to assist in creating a higher quality environmental law. Nowadays, many do realize that also in Europe, we depend for the global environmental quality also on what is done in the global south. But the way to make sure that also in the global south, environmental protection and environmental law is taken seriously is, of course, through a collaboration and to mutual respect and to listen to each other. Of course, I do realize that Europe has sometimes taken it a bit too far by trying to impose its own European standards also on countries in the south with, for example, the CSDDD, with the timber regulation, with other regulations whereby European standards are in a way exported also to the south, also to Indonesia, creating a so-called Brussels effect. That is of course very debated in countries in the south, which I fully understand, especially since many of those measures have been taken without first a collaboration and first a consultation of countries in the south. And what I would say is, I think it is crucial indeed that we all realize that the improvement of environmental quality just in one country makes no sense if other countries do not collaborate. But the crucial point is, of course, that we do that in full cooperation with each other. Ladies and gentlemen, I come to a conclusion. I hope that some thoughts, the few thoughts that I formulated here are useful and can provide you some inspiration. I wish you a wonderful conference, and I hope that I can return to Jakarta very soon and talk to you in person again. Thank you very much. Terima kasih.
So as we are waiting for the committees to prepare all things, so I would like to extend our deepest gratitude to Professor Michael Farah for his insightful and also interesting points regarding the effectiveness of environmental law. Please give another round of applause to Professor Michael Farah. So we hope this round of applause can be heard by Professor Michael Farah, as now in Europe it's still 4 a.m. in the morning. So ladies and gentlemen, before we proceed, so I would like to invite our next speakers. So the next speaker that I would like to invite you on the stage is Professor Rasika Khalid. Oh, okay. I'm so sorry, everyone. So Professor Rasika is on the restroom. So as we wait for her, I would like to also welcome the other speaker, the most well-known professor in Universitas Indonesia, Professor Muhammad Ramdan Andri Gunawan Wibisana. Also in the restroom. Okay, okay. So let us wait for a couple of minutes. So this is Professor Andri. So we wait. Okay, here it is. You can join us on the stage. Okay. Yeah, I know it's still in the morning. Everyone's busy. Also with the restroom. Okay, you may now join us on the stage, Professor. And perhaps we'll wait for a couple of minutes before. Oh yeah, so the organizing committee allow me to also sit here. And then please join me in welcoming Professor Rasika Khalid. Okay, welcome professors. Good morning. Good morning. Okay, so everyone, we will now proceed to the first plenary session, in-person session. So our next speaker is Professor Rasika Khalid, and let me check my note to read her short biography. So Professor Rasika Khalid is an associate professor at the Faculty of Law in University Kebangsaan Malaysia, and associate fellow at the Full Sail Institute, also in University Kebangsaan Malaysia. She earned her PhD from University Kebangsaan Malaysia, her Master of Laws from University Malaya, and her Bachelor of Laws from the University of Sheffield in the United Kingdom. She was also a visiting researcher at the UNESCO Center for Water Law, Policy and Science at the University of Dundee, Scotland. So in this session, Professor Rasika will speak on the triple planetary crisis, exploring its opportunities and challenges from the Malaysian perspective. So Professor Rasika, just a gentle reminder, you have 15 minutes to deliver your presentation, and you may use the podium there to deliver your speech. Ladies and gentlemen, please give a warm round of applause to Professor Rasika. The floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. And a very good morning to all. So we heard from the Professor Faur on triple planetary crisis, on the suggestion that he made on how to improve, especially in the South countries, to improve our environmental law, especially in the aspect of enforcement. But I want to share with you today is how this crisis occurs in Malaysia, and how Malaysia is working towards improving and solving the triple planetary crisis. So, but first I would like to thank icLave for inviting me to speak at 7 icLave. Okay, this is my first time to Universitas Indonesia. I'm very happy to be here. Right, so as explained just now, the triple planetary crisis focus on three aspects that have relationship between one another. The climate change, where we can see the extreme weather events that we face year in, year out, even now monthly. Yeah? And then we have pollution, which is contamination from air, water, yeah? And then we have biodiversity loss due to the deforestation activities, especially in the South countries. There are nexus between the three aspects just now, where climate change causing extreme weather, and it will cause rising sea level, affect the ecosystem, and also accelerate biodiversity loss. When we also have pollution, which causes pollution that causes health risks, environmental degradation, and to some extent threat the biodiversity. At the same time, biodiversity loss will lead to ecosystem collapse, because biodiversity provide ecosystem services which will not be balanced as a result of the climate change and pollution, and that will affect our food security at the end of the day. in Malaysia, the 3 events occurs. We are seeing more floods in the cities, especially during monsoon season, and it really affects the livelihood of the peoples in the city. We used to have floods as an annual event in the East Coast, but now we are seeing floods more often in the cities. Pollution, we have pollution, but in the remote areas where illegal factories are operating, so that is another issue that we face. For biodiversity loss, and when we look into the literature around us, they are talking about deforestation for palm plantation. We try to be very diplomatic here and discuss about politics of biodiversity loss. The aim of palm plantation, especially in Malaysia, Thailand and Indonesia, and what are we doing to help the poor, yeah, in the rural areas. And so we are actually discussing this with the European counterparts on this. Is not actually a biodiversity loss, but it's actually helping income generation for the poor. But at the same time, the new palm trees are actually helping with the absorption of more carbon and reduce the climate change impact. But in Malaysia, we have a little bit problem in terms of governance because the way our federal constitution lays down the jurisdiction for the federal and state government is for the federal to set the national policies, but at the same time, the state government has jurisdiction over the land, water, natural resources, forests, protected areas. And because of that, we do have a policy gap in terms of policy made by the federal government and implementation on the ground by the state government and also local authorities. So these jurisdictional overlap have caused fragmented governance in our environmental policy, and that delays effective response to the triple planetary crisis. And we look the issue of federalism, something our friends in Australia have improved a lot in terms of promoting cooperative, coordinated, collaborative federalism. But in Malaysia, we're still struggling. We are still competitive in many ways between federal and state, competitive policies and all that. So something that impacted our effective governance on environment. So this fragmentation have led to resource misallocation and accountability challenges since some of the money that has been allocated for certain agencies, but we do find that agencies doesn't have the capacity, doesn't have the jurisdiction over important matters. So the implementation of enforcement is not working very well. Another thing that the triple planetary crisis focus on biodiversity loss, the climate change Paris Agreement also talks about land use change and forestry. This is important to be examined because federal level, the federal government, the minister signed the Prime Minister signed the Paris Agreement, give national commitment to reduce carbon emission to certain limits. But in terms of land use change and forestry, they falls under the state government jurisdiction. And the state government has different priorities. They need money from the forest, yeah, they need income from the land use change, and that has resulted in unclear mandates amongst the agencies. The federal government has limited enforcement capacity over land use LUCF, and that has caused conflicting priorities between environmental growth and also economic growth and environmental protection. The federal government also faced challenges in coordinating whatever policies they have made at their level with the grassroots level, the state authorities and the local government level. So these have increased habitat degradation and lack of climate adaptation and mitigation among the people. And further challenges that we have seen is the weak coordination mechanism on environmental action, as has been explained earlier by the first speaker. And the accountability gap has allowed policy non-compliance. This is where Malaysia, Indonesia can learn from the California effects, the Brussels effect as explained just now, and resource constraint limit enforcement and monitoring. So if we continue to say that we are developing countries, but I think there are opportunities for us to create new technologies, okay, that will help reduce environmental degradation in our countries. If I explained just now, it's federalism issue, but we also can compare ourselves with other federations like Australia, Canada, and India, whereby in Australia, for instance, they have strong federal standard with robust enforcement and effective intergovernmental bodies. That is something which is not happening much in Malaysia because the intergovernmental bodies don't have the final say in terms of LUCF, for instance. In Canada, there are balanced federal provincial role and strong enforcement and well-established cooperation. But in Malaysia, we still have areas where funding are not being allocated to the right agencies. In India, it is complex like Malaysia, but the collaborative approaches are emerging. So just as I said, what Malaysia needs to do is to have a more collaborative, cooperative, and adaptive federalism, in contrast to the competitive federalism that we are having today. And this integrated governance will solve complex challenges that we are currently facing, and it will be smoother in terms of operation when we collaborate and cooperate among the states. And what we need to do is to establish Intergovernmental Environmental Council, to harmonize the federal and state regulation, and to build institutional capacity across government levels, increase transparency, information sharing, and promote inclusive and stakeholder participation, which is very vital in terms of environmental governance. And what I want to just share is last Friday we have the budget presentation by the Prime Minister, and there is hope in the sense of the more fundings are made to the environment. So the government has announced that 250 million will be allocated for ecological fiscal transfer. And this will help environmental conservation, strengthen state participation, and also support goals toward carbon neutrality. Another 630 million is allocated for Natural Heritage Fund to preserve the national parks and all that. This will strengthen Malaysia's economic resilience and support green transition, and to inclusive national growth, and in tackling triple planetary crisis. The EFT, the ecological forest, the EFT and NHF will try to solve this triple planetary crisis when the EFT protects forests that absorb carbon, the NHF will support forest restoration and renewable energy. In terms of pollution, the EFT will promote sustainable land use and reduce contamination, while the Natural Heritage Fund will promote investment in green infrastructure and sustainable waste management system. For biodiversity loss, the EFT will incentivize states to conserve ecosystem and wildlife areas, while the fund will conserve the parks, forests, and critical ecosystem. So at the moment, everybody's happy when more money are channeled to the environmental protection. But it remains to be seen how this EFT and NHM will roll out. But whatever it is, good cooperation between the federal and state government is very much critical for solving the triple planetary crisis in Malaysia. Thank you.
Thank you very much, Professor Rasika. You may come back to your seat. So thank you very much for your insightful presentation and for guiding us through the Malaysia's legal responses in addressing one of the most pressing issues of triple planetary crisis. So we are moving into the next speaker, last but certainly not least. It is my pleasure to introduce Professor Andri Gunawan Wibisana, Professor at the Faculty of Law, Universitas Indonesia. I'll read your short biography. So Professor Andri specializes in environmental law and law economics. He earned his master and doctoral degrees in law and economics from Utrecht University and later obtained a PhD from Maastricht University with a dissertation titled Law Economic Analysis of the Precautionary Principle. In today's session, Professor Andri will share his ongoing research on carbon crimes in Indonesia's environmental criminal law, exploring the emerging narrative of using criminal law as a mitigation tool against climate change. Professor Andri, just a kind reminder that you will have 15 minutes to deliver your presentation. You may come to the podium. Ladies and gentlemen, please give a round of applause to Professor Andri.
Thank you, Stefan, for very kind introduction. Colleagues, my presentation will be about my critics on the use of criminal law procedures to address, to discuss the issue of carbon or CO2 emissions global or greenhouse gases emissions. I call it the Indonesia's carbon crime. I think in 2013, Mark Breen writes that there has been no climate change cases alleging criminal behavior under domestic legislation or international treaty. So basically, he challenged or he questions that at the time there was no country that used criminal law to tackle the issue, to address the issue of greenhouse gas emissions. However, in 2024, to my surprise, an Indonesian wrote and published in Nature an article titled "Climate Change-Related Litigation in Indonesia." So in the article, I appreciate the articles because this article brings the Indonesian cases into the international journal, prestigious journal like Nature. And the article mentions that the article collected several cases related to climate change and using the words. I mean, basically, she goes to the website of the directory of the Supreme Court and type some keywords such as greenhouse gases or gas rumah kaca or climate change, and she found several cases. I also did the same thing with the keyword greenhouse gas rumah kaca. she found 112 cases. I found 120 cases. And then, majority of the cases apparently are the cases in the criminal procedures. So, and this article says that it is a breakthrough in the sense that using criminal law procedures to address greenhouse gases. So, 80 criminal cases, I found only 90. I found 97 actually. Perhaps because of the time, I found 97 cases. Indeed, discussing in criminal cases, discussing or addressing the issue of greenhouse gas emissions or climate change. So my question is, are these cases really a breakthrough in climate litigation? Because usually climate litigation is talking about tort or about the litigation against the governments to reduce emissions. So are these criminal cases really breakthrough in climate litigation or a breakdown? In the sense that if it is breakthrough, then it is worth replicating in other countries. If it is not, then perhaps it's just climate change litigation out of FOMO, or of ignorance perhaps. So I see this before I go to the analysis. I think it's important to break down the criminal provisions that are related to these cases. There are two categories. The first one is crime consists of result crimes. Provisions consist of result crimes. So result crime provisions. The conduct becomes punishable only when it leads to specific consequences. In this sense, environmental pollution or degradation. In our environmental law, these articles are Article 98, 99 of 2009 Environmental Protection and Management Law. And also, similar provisions can be found in Article 48 and 47 of 2004 Plantation Law. In the sense that you do conduct a crime, but then it will only be a crime if there's a pollution out of your conduct. And one of the pollution, of course, here in Indonesia it's translated as the accidents, the violation of quality standard, environmental quality standards such as air pollution standards, air quality standards, water quality standards, seawater quality standards. And the second category involves conduct crimes. An act itself constitutes a crime simply because it is prohibited by the law. For example, regardless of the harm, of course, or the consequences of the conduct. For instance, clearing the land through burning, so by the means of burning. So here we can find the offense in Article 108 of the Environmental Law, the 2009, and also the Plantation Law, the new Plantation Law of 2014, Article 108. And here are one of the example here. The case of Cosman Vitoni Siboro. He was an assistant estate manager at a corporation, an oil palm company operating on peatland. And the peatland, he was charged on for wildfire on the company's land. And the charge committing an offense, the result crimes provisions under Article 98 and 99. 98 is for intentional conduct, 99 is for negligent conduct. So the prosecutor claimed, you see, that during the fire, 900 tons of carbon were released, 3,150 tons of CO2, 32.36 tons of methane, 14, and so on and so forth. So these are the cases that are always discussed in almost majority, like 90% or 80% of the cases that I found in around let's say around 70 cases, yeah, discussing these emissions from forest fires. Then, these are other examples. I just got 10 cases here, put 10 cases here. So, in one case, the case was climate greenhouse gases were specified in these cases, in case number 1, and also the prosecutor, based on the Article 99, the intentional result crime, and punish for pollution, meaning punish because of the emission of greenhouse gases. The punishment is 1 year and 2 months imprisonment and a fine of 1 billion rupiah. Quite a lot. Yeah. And see that there's also cases like this one, but with the variety of the sentences, of course. What are the problems from these cases? Here, again, the court stated that the release of the greenhouse gases during the fire exceeds environmental quality standards. Okay, so the question is, what kind of environmental quality standards that we have? Again, I will discuss that later. So, the emissions, it means that greenhouse gas emissions were considered criminal act, causing air quality standard to be exceeded. And in Kosman Siboro, he was sentenced with a 2-year imprisonment. Can also find in other cases, right? In other cases, that's for the result crimes. In conduct crimes, defendants were sentenced with the conduct crime provisions, namely conducting land clearing by the means of burning. And in these cases, greenhouse gases were mentioned as the result of burning, of fire. However, the defendant criminal conducts, namely the burning, are already a crime actually, regardless of the resulting greenhouse gases emissions. So without mentioning or discussing greenhouse gas emissions, actually burning land is already a crime, regardless of the consequences.
Sorry to interrupt you. You have 5 minutes left.
So gases claimed by prosecutors and judges, CO2, carbon, CO2, CH-methane, NOx, are these gases greenhouse gases? So if you look at the Kyoto and Doha, when we are talking about the greenhouse gases, we talk only about CO2, methane, nitrous oxygen, hydrofluorocarbon, perfluorocarbon, sulfur hexafluorides, and nitrogen trifluorides. So there is no NOx, NH3, ozone, and carbon monoxide. So these are not greenhouse gases according to Kyoto and Doha. So let's see our ambient quality standards. Do we see greenhouse gases here? CO2, for example. No, there is no greenhouse gases here in our standards, right? This is the previous one, and this is the new one. See, you can see from our government regulations. So what does it mean? It means that our violation, punishing greenhouse gases emissions with the Article 98 and 99 is actually a violation of the principle of legality, the basic principle of criminal law. So, and also using emissions, because all these emissions actually as the basis to prove the exceedance of ambient air quality standards also misunderstood the fundamentals of environmental law. Because if we talk about emissions, the exceeding of emissions standards, we should talk about Article 100, not Article 1998 or 99. So there is a specific provisions in our law for punishment for punishing the accidents of emission standard. So we have to make a distinction, clear distinction between the air quality standard and emission standard. Using emissions to punish based on the violation of ambient quality standard is a mistake. So if they were the students, they will fail my class because that's the basic that we should understand. Cases using result crime provisions are based on misunderstanding of greenhouse gases, as if all greenhouse gases are air pollutants, or vice versa, all air pollutants are greenhouse gases. So I think this one is the new level. The use of greenhouse gases in corruption case. I just look at the carbon release cost. Then based on this one, so I go. My critic is that this calculation, including the calculation on Nur Alam case, the corruption case, use the calculation, the numbers in the examples, not real calculation, examples. And then rather than calculating the damage according to the actual restoration plan, the evaluation is based on examples. And if we follow the prosecutor's logic, the release of greenhouse gas emission from illegal conduct is equal to environmental damage and is equal to state loss, and then because of that it is corruption, then beware, everybody. Speeding in Indonesia may be prosecuted as a corruption offense. Because look, speeding is violation of law, and then there's a emission because of the speeding, and then you will speeding, and the emission will be considered as the state loss, if we follow this kind of argument. So my point is, I can come back to the final question. This is the last point that I make. Is it a big breakthrough or breakdown? Then you know already the answer. At best, it is a bitter dicta, especially when it comes to the cases of conduct crimes, right? Because greenhouse gases has nothing to do with the issue of whether the defendant will be punished or not. At worst, the cases illustrates a miscarriage of justice rooted in limited understanding of greenhouse gases, the improper application of result crime provisions, and a violation of provision of legality. Before I conclude my presentation, I think the Indonesian carbon crime reflect or indicate something more, something subtle, but a more serious problem, serious issue. Namely, the problem in the quality of the law schools, or legal institution in Indonesia. Why? Because, you know, for your information, none of the lawyers in these cases ever challenged the calculation of greenhouse gases. None. Only one court dared to challenge the calculation and dared to argue that I don't want to use the calculation of greenhouse gases because these greenhouse gases are not in our air quality standards. So with that, I conclude my presentation. Thank you very much.
Thank you very much, Professor Andre. Then Professor Andre leaves the question to us, whether you want to see this as a breakthrough or as a breakdown, okay? So yeah, after the series of highly engaging and thought-provoking presentations, however, due to time constraints, we cannot welcome all the questions. And yeah, there are all really a lot of participants now raising their questions. So now I open the floor for a Q&A session. So yeah, we have two participants here already raised their hands. So perhaps the perhaps the first sir is here. Please introduce your name and your affiliation.
Thanks very much. My name is Professor Yusuf Leonard Hinuk. I'm from Kupang. And this is my second time. Last year I joined the conference too, and I have good friend with the chairperson in the back. My question is in Malaysia. Why you stay with near Singapore But you compare to to what? To Australia. This is not good. And why you use the wig? I mean, you use the wig. Wig. But in Australia and Canada and your neighbor Singapore, they're doing bad. How you do that one? The second one for you is, you know, he talked about the fire. We in Indonesia, we export smoke. You know, we export smoke. How you respond to the problem with Indonesia? From Indonesia, like export smoke because this pollution. And then for you, you mentioned about the law school. Now the question for you, you as a professor, what you do to do that one? This the professor, you must do the best for the country. Why? You go to the overseas and you study the good one. You come here, you don't do well for your country. Thanks very much.
Okay. So yeah, thank you very much, Professor. Another professor to another professor. Okay. So yeah, I'm so sorry because I received a sign that we only received one question from the organizing committee. So yeah. Do you get all the questions?
Yeah.
Yeah.
I try to answer that. Thank you, Professor, for that question. Why I don't compare with Singapore? Because they have different structure of government. They are unitary system, while I'm comparing the federal state system. So Singapore is a unitary system. They are very good. They have good example. In fact, they are the country that everybody in the world is looking in terms of water management and all that. But they can do that because they are unitary system. From ministry straight to the agency, straight to the people. But we have many layers of federal, state, local government level that sometimes they are not coordinated. The second question about, I believe it's about haze. Well, no comment. I leave it to answer.
Thank you, Prof. Rasika. A couple of months ago, a couple of years ago, with some NGO, I worked with the Supreme Court to draft provisions. We tried to adopt the US, the American market share liability, and this is important because then all fires cases never talk about haze, So a lot of cases in Indonesia, including government lawsuits against companies, they never talk about haze. What did they argue, the government? It's only about the degradation of land, of peatland, because of fires. Why they avoid the issue of haze? Because of the problem of causation. You know, to prove that the damage suffered by the government or by the public is because of the emissions, the haze coming from the defendants. So because of the problem, we found the concept, the market share liability concept in the US, and then applied it. We call it in the environmental, the pollution share liability, and we drafted, and the Supreme Court agreed. So it is now in the Supreme Court, Article 46. So in the sense that, meaning that you just can go after one company whose land was on fire, and then ask the compensation, ask the liability, and then the burden to prove that he's not liable or the other people could also be liable is not in hand of the plaintiffs, but in hand of defendants. Unfortunately, we tried to exercise this article in a case in Palembang. Fortunately, I hope in July the court will be ruled in favor of the plaintiffs, because this was the first case in Indonesia on haze. Unfortunately, the court rejected the claims, so we see in the Supreme Court now. So if we come with the good news, then I will tell you. It means what it means, because it means that Malaysians, Singaporeans can file lawsuits in Indonesia because of the haze. I think we need a legal breakthrough, legal innovation to handle this kind of situation, because otherwise there is no deterrent there is no deterrent for the companies, because then the annual fires happen and happen again. And the question for me with respect to the quality also, this is the thing that I'm always doing, actually criticizing my colleagues, the concepts, even the cases here, and I think that's not easy, even because then it costs me a lot, because sometimes my critics some people get offended because of my critics, but I will not stop at that just to criticize and publicize this the finding. I hope my finding can be published in a good journal, or at least in Indonesian journal.
Okay, and that marks the end of our very engaging and also thought-provoking presentation and also discussion. I would like to thank you once again for all the presenters today. Unfortunately, for all participants, we cannot extend our duration due to time limit. And now, I would like to return the floor to the Master of Ceremony.
Plenary session. Please give us the warm applause. For this plenary session 1, thank you so much, Zevanya, and also to all panelists, professor, thank you so much. Therefore, I would like to invite Dr. Choki Rizda Ramadan to come forward, joining us and present the tokens of appreciation for both of the panelists and also our moderator. So please, I welcome Mr. Choki. First for Professor Rashika Khalid, and please take a picture of this, our photographer team. Ladies and gentlemen, please welcome the second for Prof. Andri Gunawan Wibisana. 1, 2, 3. Thank you, Professor. And the last but not least, for our moderator, Zevanya Albrena. Oke, 3, 2, 1. 1, 2, 3. Thank you so much. Ladies and gentlemen, please give the warm round of applause for this plenary session 1. Thank you so much for Professor, and also please to the central of the stage to take a picture together from the plenary session 1. Yes. Our photographer team. Three, 2, 1. 1, 2, 3. Thank you so much, professors, and also Zevanya for leading us into the plenary session 1. And now we have reached the time for our next discussion onto the plenary session 2. And in this second plenary, we will continue our exploration through the topics of the conference theme itself, the dynamics and challenge in law journals. And in this session, it will be chaired and moderated by Rizky Banyu Alam, SH, LLM. Rizky Banyu Alam Permana is a lecturer at Department of International Law, Fakultas Hukum Universitas Indonesia, holds the Bachelor of Law from Universitas Indonesia and Master of Law in International Trade and Investment Law from Maastricht University. And his research focused on international trade and investment law. So I please welcome Mr. Rizky Banyu Alam Permana.
Check. Very good morning toward almost noon now. So this is the most challenging session that I have ever had because we're nearing towards the lunch break. But however, this session will explore not directly related to the theme itself, which regarding the sustainability, democracy, and also the development. But this is not less important because we all know we are the academia. Academia needs to publish to disseminate our idea elsewhere. However, unfortunately, thinking about journal is like thinking similar with black box. We publish it, and we don't know what happened inside, right? And you get the decision whether you are accepted or rejected. Now we want to know what happened inside. That's why, fortunately, we are able to host 4 editors from the most prestigious journal in the region. So I'm going to invite now the editors who is attending today in person and also through Zoom session. Please welcome Professor Arya Friansyah from Indonesian Journal of International Law as the editor-in-chief. Please give applause. And the second in-person editor journal already present here is the Dr. Patricia Rinwigati Wakstein from Indonesia Law Review. Please give applause to her. And also, please give applause to Dr. Teresia Dia Wirastri from Indonesian Journal of Social Legal Studies. Please give applause and please take to the front. And also, I'm going to greet Dr. Arif Jamal. Are you there? Can you hear us? Okay. Good day for you from live from Singapore. So, yeah. I'm not going to read the profile because we have limitation of time. So I'm going to elaborate about the discussion and order of the discussion. First, we will have Dr. Jamal from the Asian Journal of Comparative Law here, talking about the experience and the profile of the journal itself and the expectation. And the second speaker would be Professor Arya Friansyah from Indonesian Journal of International Law. And the third speaker would be Patricia Rinwigati from IREF. And the fourth and the last speaker would be Indonesian Journal of Social Legal Studies. Because we have limitation of time, I hope we can squeeze the presentation into like no more than 10 to 15 minutes. So in order to we have more discussion later on. So first, for the first speaker, please welcome Dr. Arif Jamal from Asian Journal of Comparative Law. Please give applause.
Thank you very much, everybody. Assalamu alaikum wa rahmatullahi wa barakatuh. And thank you for the invitation to join this editors panel in the 7th icLave conference. I'm sorry that I've not been able to be with you in person. As much as I would have liked, and as much as I've enjoyed my prior visits to Jakarta. I am grateful nonetheless that the technology that we all now have become quite familiar with enables me to join you remotely. I have understood my brief for this session as sharing some of the experiences I have had as one of the editors-in-chief of the Asian Journal of Comparative Law, or the ASJCL as we call it, especially for potential authors. So I would like to share some reflections which are general about what I've seen, as well as some observations that relate more particularly to submissions that we get from Indonesian authors. Let me start by saying something that I know won't be very encouraging at the outset, but then suggest why this story is not really one of doom and gloom. The ASJCL receives something like 150 to 200 submissions a year. We receive a healthy number of submissions from Indonesians, but we ultimately publish very few pieces written by Indonesians. In other words, most of the submissions that we receive from Indonesians are not accepted for publication, which I know sounds like doom and gloom. This is particularly unfortunate given Indonesia's size, its influence regionally as well as internationally, and frankly, how interesting Indonesia is. What can be done about this, and why does this happen? So before I go into a list of issues, let me take the opportunity to discuss our process to maybe shed light on the black box that we heard about. When a submission comes into our journal, it is first reviewed by our administrative team and then by one of the editors-in-chief, who decide whether or not the piece is sent to one of our editorial board members, who will run a peer review process. Occasionally, we will ask an editorial board member to do what I call a triage review. That is, if there's something that looks marginal to us, we ask this member of our board to help us decide whether even to send it to peer review. If we do send it, it is given in carriage to one of our, what we call subject editors, who will then invite peer reviewers. We operate a double-blind peer review system and usually want a minimum of 2 peer reviews. The reviewers are given a pretty normal range of options that they can do, and both the subject editor as well as the editors-in-chief will look at their comments. We ask each of our subject editors to give us a recommendation, and then the editors-in-chief finally sign off on whether to publish or not to publish. The type and quality of reviews that we receive varies. I recently had the pleasure of accepting one paper which had some really excellent peer reviews, really engaged with the submission, very thoughtful. But the range is there, although I would say that more often than not, we find that the peer review reports are in broad agreement or consensus. It is rare to receive peer review reports that are at opposite ends of the spectrum. Absolutely yes or absolutely no. All right, so let me now turn to these issues that I said I would talk about and some of the challenges that I find occurring. The first issue that I would like to raise is the question of structure. Too often, particularly from certain parts or certain jurisdictions in Asia, we receive submissions that seem to follow a very formulaic structure. Introduction, thesis statement, methodology, etc., etc. Although I can appreciate why people might be trained this way and what they might feel comfortable therefore following this sort of formula, these formulaic expositions come across as rather undergraduate in style. Not all papers, not all submissions need to follow exactly the same structure. And some of the more interesting paper don't try to follow a structure like they're ticking a box. So that's the first thing I'd like to talk about. First issue I'd like to raise. The second challenge comes from the development of a thesis or argument. It is unfortunate, but frankly true, that in some cases, too many for my liking, but in some cases, authors provide us with a description, but not a thesis or not an argument. That too is not something that's going to meet the publication standard for a journal like ours. Third, whether we like it or not, English is the international language, and sometimes submissions are let down by the quality of their English language expression. This becomes a challenge because of the amount of editorial work that might be necessary to take a good submission, a good topic, and improve the language. But I'll have something to say about that in a moment. Fourth is the type of comparison or comparisons that are made. I was listening into the last panel at the end, and one of the questions was about the forms of comparison. Why does one choose certain comparators and not others? There is a tendency sometimes, I think, from scholarship coming from Asia to always compare to the Western jurisdiction. And sometimes a tendency to compare to the former colonial jurisdiction, the United Kingdom, the Netherlands, whatever it may be. And while I'm not saying that we should not look comparatively to the West, whether that is the Netherlands or anywhere else, I think it is important to be willing to prepare, or to present rather, alternative frameworks. Comparison within Asia, comparison to perhaps less well-known jurisdiction. Not all of the big ideas will come simply from a comparison to the West. Fifth, and related to the point about comparison, as I'm sure many of you are aware, there are currently trends in comparative law, as well as other areas of law, such as international law, towards decolonization or third-world approaches. You see this in international law with the phenomenon of TWAIL, the third world approaches to international law. Now, not everyone adopts these approaches, and whether you do or not, or even if you reject these approaches, is entirely fine. But it is important to show some thoughtful and nuanced analysis. And that is why too often I've seen a comparison of Asian jurisdictions with a jurisdiction in the West with the simple conclusion that that what's happening in the West is simply better than Asia, and it lacks nuance. Related to this, and the sixth point I'd like to make, is that the Asian Journal of Comparative Law does not see Asia at all as exotic. Rather, it recognizes that Asian societies and jurisdictions are dealing with many issues that are common to other parts of the world, but are perhaps doing it with their own specificity and their own approaches. So, while we are not looking for Asian exceptionalism per se, we are looking to be a place where what is happening within and between Asia, or where, as it were, the Asian voice might be given expression. So having raised some of these issues, I said earlier that it's not all the story of doom and gloom. And let me tell you why I think this is the hopeful story. It is hopeful simply because many of these issues that I have raised are, I believe, quite easily solvable or remediated by some reorientation. If I go back to the list, let me start again with structure. It is simply a question of choosing a structure to fit the paper rather than trying to make the paper fit a predetermined and formulaic structure. Choose something that works. Choose something that makes sure that the paper is presented in its best light. And look at different examples from different journals or from more senior scholars. Second, the idea of developing the thesis and argument and of forefronting that thesis and argument should really not be a challenge. But simple description to repeat what I said before will not work. On the quality of English language, although this has often been a challenge in the past, I think the prevalence of AI tools now can really make this much better. Of course, one has to declare when one is using AI, but some of this AI can rewrite what might seem problematic English and polish it to a very high degree, and do so quickly and efficiently and with great clarity. And fourth, to the idea of the comparison and to the challenge of comparison, I would simply say, please don't be shy or be concerned about making comparisons about Asia, within Asia, and raising the Asian voice. So those are the thoughts that I wanted to share from the experience of the Asian Journal of Comparative Law. Let me conclude by thanking you all once again for letting me join you. Apologize once again for not being able to be with you in person. And finally, invite all of you to please consider making submission to the Asian Journal of Comparative Law. Thank you.
All right, thank you so much, Dr. Arif Jamal, for your presentation. And please give applause. So now we kind of know what kind of expectation the editor of journal would expect from us, the author, right? So I believe that most of the journal editors will share the same opinion, but it comes again down to the scope and focus of the journal. So in order to make the time more efficient, I know some of you have already questions. Let's switch the format. Instead of we're having the more or less same talk all over again. Now I'm going to ask the journal, the editors here, about their perspective and that common problem that they have. So in that way, we can see how the expectation from each editors are will be the same, and to what extent the expectation will be different, right? So now, after because Dr. Arif has explained the baseline of 101, what does the editor expect? Now we're going to ask the remainder. So probably for the editors that attend in person, and I'll come back to you later on, Dr. Arif, and maybe I will ask a question, simple question like this: how hard to get published in your journal, and what kind of article that you expect? Because we know that Dr. Arif Jamal explained here that you need to have a more thesis argument, and you have a more proper English polish on your manuscript. I think it's a common problem that we have. Now, let's go to each particularity that each journal have, and what kind of article that you expect. Maybe first I come to Prof. Ari first as a
Indonesian Journal of International Law Editor-in-Chief.
Okay, thank you, Banyu. Ladies and gentlemen, thank you for having me. I guess the committee I know the reason why these three panelists sit together, because in this faculty, we are the chief editors of the journals that have been indexed in Scopus. So I guess this would be a challenging for us, because we are now on the spotlight that we need to have more publication that really have a quality over the quantity right now. So as for me, because the Indonesian Journal of International Law, of course, it has a very focus on international law issues. I guess the journal is kind of a more broader audience, and also wider scope to cover. However, the journal itself try to try to have a niche on how it can be developed, how international be developed, more in the southern hemisphere. We try to make a balance of perspectives that's coming from the northern part, where international law is mostly so-called very European centrism. So we try to have a more balance. Despite that, again, this is the challenge for the editors, because we have so many submission, but then when it comes to the quality, as Pa Arif have mentioned, that we are struggling, trying to understand what's the point of your article, what is your main arguments. Sometimes the editors have to read from the beginning until the end, yeah, and then we know what is the final argument. This is something that we need to change. That we have to be bold in providing or stating our arguments in the beginning of the article, and of course we are expecting more collaborative authorship. It doesn't mean that if you are not co-authorship with foreign affiliators that you will not be accepted. No, but now it's more on how we can develop and more enhance our capacity. Yeah, when we have more on a collaborative side. Me personally have a just recent experience that I co-writing with a professor from the Newport College. I got this experience that when you're writing, it is a committed or dedicated issue. Yeah. Sometimes here in Indonesia, at least I speak for myself, that we are so busy with other things when we have this commitment of writing. I learned so much from him that if you're committed to do a research and then to write, then you have to allocate your time seriously into your commitment. And with this serious commitment, I can feel that, and I experience that the better the quality of your article will be. So as for the journal itself, I guess first you have to, again, it's about the journey. It's not all about the result. I mean, if you are talking about the result only, now we have so much assisted from generative AI right now, yeah? And we have so many trouble with this so-called paper mills issue. And we don't want that. That's why this writing becomes the journey, yeah? The journey that will become or will resulting in a very meaningful publication. You write for yourself and by yourself, yeah? And you can know how much development that you can get, both personally and also for the institution. Thank you. That's for me.
Same question. How hard is it to get to your journal?
It's not hard at all. I mean, it's I'm managing actually Indonesian Law Review. Yes. In fact, actually, the Professor Ari was the one who initiated, as well as to develop on the first phase. But then I continued after the adoptions, after the journal is being indexed in Scopus. I think it's not difficult at all when you know which journal that you are basically targeting to. The second of all is like read the editorial message for the reader, for the writers. I think in the case of icLave, it's very general. The scope is quite general. It's about legal development in ASEAN with a perspective ASEAN as well as the Global South perspective. So it's very broad. Even talking about the national law of the Global South, that's also possible. So it's really broad in that sense. As long as you're using basically the Global South perspective. And then you can use basically different methodologies. The second of all has to be straightforward, clear. The idea that you're gonna present it is very clear, and don't go around. This is a tendency of the Indonesian writers. Basically, you go around and around. Just pick one topic that you want and go deeper. I think that's the issues. And then the third is basically about the references. Please use the references the last 5 years if it's possible. So to make it basically the journal updated. And then the fourth is basically collaborations. Indeed, as Professor Ari said, collaboration is encouraged. Nevertheless, we continue our classical rules, 3 versus 3. 3 basically for Indonesian writers, and then 3 for non-Indonesian institutions writers. So we continue with that. However, they can also mix if there is a collaborations, and therefore collaboration is very important. Why we give actually 3 priority, not really priority, but a quota for Indonesian writers, because we know nowadays publications become a mandatory institutional obligations. I think all of us basically know that publications required to get a promotion, to pass the exam, also graduate. Therefore, I think it's very important basically to give space for our Indonesian colleagues without jeopardizing the quality of the article per se. And then the third, basically, in order basically to maintain our quality, usually we work together with the conferences, because that's basically how we can have a double, quality control. Because one is already published, one somehow already presented, and usually in the conferences they also have a committee who are going to look at the quality of the papers that are going to be submitted. And therefore, I think collaborations with international conferences, that will be very much, we want to have that. And I think for next year, we have also collaboration with Southeast Asia Human Rights Network with their conference in Laos, 2026. So that's basically one of the output will be, if it's, meeting our requirements, that's also, we can actually consider to publish in our journal. I think that's how we try to balance between, giving the priority for the Indonesian writers without jeopardizing the quality, as well as also still holding the missions that we are going to disseminating the development of legal science. Thank you.
Thank you so much, Dr. Patricia. Let's give applause. And same question to you. I'm interested to listen to your story because you're managing socio-legal journal, which is quite rare in Indonesia, and particularly research of law in Indonesia deals mainly with doctrinal mainly, and how would you expect the author to submit to you your journal? Please.
Terima kasih, Mas. So, good morning to all of you. First of all, thank you so much for the organizer for initiating this kind of event. I think this is a good way of interacting between us, the editors, and also Ibu dan Bapak as potential authors for our journals. So coming back to the question of how hard it is to submit to the journal itself. So I'm currently managing the Indonesian Journal of Socio-Legal Studies. So by the title of the journal, it's already reflected that a very targeted audience of the journal itself. So we're rather niche in that sense. And I don't know whether that is a good thing or rather difficult, but looking at the past 3 years of our journey, so for every edition, we have 5 slots for articles. 5 of which will be divided 3 English articles and 2 Indonesian articles. So we built this journal by having in mind that we will provide such platforms, especially for the Indonesian scholars who put their mind on socio-legal studies. But what happened in the last 1.5 years was that out of 5 slots of articles that we received lately, all of them are in English. So not much of the Indonesian scholars are actually writing in Bahasa anymore, at least the one that is submitted to our journal. So please, if you have a good socio-legal journal in Bahasa, I would strongly recommend you to send it to our journal. Because I think the emphasis is still, it's on the Indonesian aspects of socio-legal studies. And if the question is how hard to send it to the journal itself, so by the beginning of this year, the acceptance rate for our journal is less than 30%. So we have a rather high rejection rate of more than 60%. Yeah. And in the end, as what my fellow editors have said, publishing a journal is not an instant journey. It takes a lot of hard work and also, I think, maturity on the topics that the authors have decided to choose. Especially when putting the socio-legal perspective into it, then it becomes, you know, like slightly narrowing down. So, yeah, I think the combination of the 3 journals in the law faculty, Universitas Indonesia, I think this is a good balance. I mean, we have a journal for international law and also for Indonesian law review, but if the focus is on the socio-legal lens, then especially on the issue of Indonesia, then that is something you can submit it to our journal. And for the foreign authors, we kept getting this kind of question, whether it is possible to write socio-legal studies on other countries. It is possible, but then one of the requirements is to make it as a comparison study to the Indonesian socio-legal studies. Yeah, I hope that answers the question for now. Thank you.
Thank you so much, and please give applause again. All right. So we do have time around 20 minutes-ish. So not yet, Pak. So because this is but worry not, we can still interact with the editors here who attended in person. You can ask their question after this session. Of course, they will still be around. One key question that I want to address, because the session is talking about the challenges, and the previous speakers, Dr. Arif and Professor Ari, mentioned about the elephant in the room, that is the AI, generative AI. Because it's quite unclear for many Indonesian authors, particularly even myself, where's the line? Where are you drawing the line? In fact, if you want to polish your English, of course, the generative AI is the tool that you can use, but where's the line? Where's the ethical boundary that need to be still observed by the by the authors. That's why we need to hear from the editors directly regarding this approach, because there are so many development, there's so many uncertainty. Of course, generative AI can help us, but in what way? So I want to hear from you first, Dr. Arif, regarding your point on the use of generative AI and to what extent your journal will allow it, and what are the lines, please.
Yeah, thank you very much for this question. It's a good question, of course. So we're published by Cambridge University Press, and one of the questions that we had raised with Cambridge was about their own policy. And it may be surprising, it may not be surprising to know that because of the developments and because things are moving so rapidly, it is very difficult to draw a line in the sand because the sand keeps shifting. So we have taken the following view, which I think is consistent, which is consistent with the policy that Cambridge has used generally, which is, if you are going to use AI, you have to say what you're using and what you've used it for and what tools you have used. Now, having said that, we certainly don't want a journal that says, these papers were all written by ChatGPT, right? That's not what we're trying to publish. It is increasingly challenging to discern what is being generated by the generative AI and what is being done by human hands, right? So there's no foolproof way of checking. And you called it the elephant in the room. I would say that the genie has been let out of the bottle, and the genie cannot be put back in the bottle. The AI genie is out. So we're all going to struggle with it a little bit. Our policy, therefore, to be clear, is that it can be used, but we have to have declaration of how it is used. And frankly, within our board, the use of AI tools to improve language, structure, clarity, that's one thing. I think we would be quite happy or quite content for AI to be used in that way. The use of AI for generating ideas or content becomes much more problematic. And if we see that, and we recently had one submission which actually one of the peer reviewers found that, then we are likely sort of not to publish, because as I said, our job is not to publish what ChatGPT can produce. I hope that helps.
All right, thank you so much for the clarification. Then we will move forward again to Professor Ari, please.
Yes. I think as an editor and also as a scholar, I don't think we cannot deny the existence of this so-called technology-assisted publication. But the most important thing is that we are educated and we are quite aware of the ethics of when we are using the tools like the generative AI. The tool itself has been very helpful, but then we cannot let the tools give us other intention of producing for a different purpose. Yeah. For example, when you try to impress the editors by making many citations, but then the citation is fake, for example, yeah, and then you try to again impress the editors by making the sentence so complicated, and then the editors cannot understand it. Yeah. So all of those things you can do with the AI, but again, writing the articles is the journey for yourself, yeah, for your own capacity to improve, yeah, not the result itself. So I guess we don't want to. We have so much attention, of course, about the integrity of the research, we have known about so many articles talking about how articles is made. One of them is Indonesia, that violating ethics in the publication. It's very sad for us, but then it is up to us again to change all of that. Thank you.
Yeah, I just actually copy what Professor Ari said, that AI is basically a tool, it's not the destinations per se. And then we cannot avoid basically writers basically to use the AI. And I think AI is good to generate ideas as well as to edit the language, to help you to edit the language. Although there is a tools also to check it out, the Turnitin. But again, in our case, in icLave, we actually are looking at it, and then you can already see, because we are also lecturers, that we can already see which one is basically coming from AI or not. Usually they have this tendency to have elaborations, conclusions, and then allusion. Finally, it's just so common because we also somehow check it out, time to time with different AI. So I think one thing which you cannot use AI is basically the analysis and the court cases, that usually something that we look at it. And then if we find out that there is a doubt that this writer basically using the AI more that is intended, what we basically said in the beginning. So we have basically either to withdraw the articles, to tell actually the board, the editors itself, and also we ban basically the writers. That's what we do.
Thank you, please.
That's actually good to ban. I haven't I haven't done that yet. So okay, so for our journal, if an article is being submitted, then we automatically have two types of screenings. First one is we will use Turnitins in order to get the similarity index or similarity score, and then afterwards we will also use other software, for instance like CopyLeaks, to check about how many high or low the use of AIs in one's article. And usually we will also divide that into whether it is AI generated ideas or it is just being used to tailor the sentences, for instance. When it comes to the use of AI to help someone in building up sentences, I think to a reasonable extent, we will allow it. But as the other editors have also said, I mean, for me personally, I would rather to have a very simple text or a very simple manuscript coming from the Indonesian author, because at the end of the day, English is not our native language. So what is most important for us is if the ideas can be conveyed in a good way, then we will take it, rather than like tailor here and there and make it into a more sophisticated languages, but then get lost in your own sentences. So, but what is now in our concern is on the first purpose, like to what extent will we allow this AI generated ideas and in reshaping or shaping your manuscript before sending it to us. Because especially on the field of social legal studies, mostly it's not pure doctrinal analysis. It will also come with a more empirical aspects of your research. And that will be the strength or the core ideas of your manuscript. So with the use of AIs, then for us we will double check it, like how extensive are you using it? But especially on the analysis part, I think we are trying not to allow the use of AIs, because at the end of the day, it should come for your own analysis. but this is also one of the things that we have to think forward, like the guidelines on the use of AIs in writing a manuscript, and also the ethical side of it. Because as far as I understand, we don't have a consensus on it. I mean, people can come up with different arguments and their own rationales, but I think it is good if we have like some sort of a common sense on the ethical side of the use of AIs.
Okay, thank you so much. Right, it's almost to noon by now. I think there are still so many burning questions on the floor, from the floor. We can allow, I think, one questions from the floor. 1, 2, 3. Okay. Yeah, I think we for the general balance purpose, yeah.
That's okay. Thank you so much for the opportunity and for the materials that all of the speakers presented today. So I have a question. In your experience as journal editors, how do you view the role of article processing chargers or APCs in sustaining a journal's operation? Are they absolutely necessary, or should there be room for flexibility? Thank you.
Right, this is quite sensitive and important question because, yeah, usually junior scholars like me, it's quite broke, we cannot pay it. So I think for each journal, this is the question for each journal. Dr. Arif, the question is about APC. How do you charges, and can you accept like some kind of waiver, and how junior scholars particularly can access your journal without like a proper source of funding? Thank you.
Thanks. So we have no article processing charges, none at all. And I should add, on the other hand, on the other end of the spectrum, we are now a fully online journal. We don't have a print edition, a hard copy edition, but institutions can enter into these agreements with Cambridge University Press. So from 2026, we are going to be fully open access. So no charges and fully open access from 2026.
All right. So, so I think I lost the last part. Can you repeat that again?
Yeah, I was just saying, so in terms of the charges, we have 0 charges.
Okay.
And we are going to be fully open access from 2026. What they call gold open access.
Now I see the interested eyes because you mentioned 0 charges for the article. So yeah, take the note, right? So please, Professor Ari, about e-journal practice and IREF and Indonesian Journal Socialism.
I think in general, I can speak on behalf of the 3 of us. Because we are under the same management, the Faculty of Law, Universitas Indonesia, and currently we are not having any APC, because we're still subsidized by the faculty. However, for those journals that putting their APC, it can be, well, we can understand, because running the journals needs someone or some people who taking care of the journal, and they need to be paid. This is not something that of voluntary work, pro bono work. Yeah, in order to get a very quality publication, then you have to pay attention to the ones that are running the journal as well. If you take a look at the very top prominent journals, that they eventually get their APC very high, or they can switch to the open access options. Yeah. So if you want to be an open access article, then you have to pay thousands of dollars or euros. Yeah. But again, if your institution already have this so-called agreement with the publisher, then you'll be safe. Yeah. And this is also not only coming from the early career scholars, but also some seniors, yeah, that sometimes we don't have the resources or the funding to cover all of the APCs in, of course, our targeted journals. But for, at least for the three of us, we are not yet thinking about putting the APCs out there. But for Indonesian Journal of International Law, we are still, now we're requiring the accepted articles to be proofread by the funding from the author itself. Yeah. However, we also sometimes waive this obligation for those articles that's really good quality, but then he or she cannot afford for this funding for proofreading. Thank you.
Amin.
Can I just add one? Can I just add one thing to what
Yeah,
we said?
so-
Yeah, which is, I mean, the first speaker was entirely correct. Journals cost money, right? And somebody has to pay for it. Our journal, the journal that I'm with, the Asian Journal of Comparative Law, we get, it's NUS law that's helping to fund this. But if we didn't have that support, yeah, then you have to generate the money somewhere. And you don't get a lot from your publisher. The publishers, the royalties are very, very minimal.
Right, so this is the tricky question that still we have that. So I think we can fit one more question. Yeah. From there, yeah.
Okay, thank you for the opportunity. My name is Nabila from Faculty of Law, Universitas Negeri Surabaya. First, I'm sorry if my question may be out of topic from the three journals that already mentioned, because I'm going to ask about Indonesian Journal of Environmental Law, icLave. So maybe is this the same regulation of the journal, because for this event, the system suggests my paper to submit to this journal. That's my first question. Is it the same regulation or arrangement? And then the second is, how long the process, maybe from each journal, is it the same process from the submission until at least we, the author, get the review from the editors? I think that's all my question. Thank you.
All right, so thank you, Ibu. So on icLave, I think Pak Zefan here will assist you later on because he is not here. Oh yeah, please, yeah, later on, yeah, Ibu. Then for the length of the processing, I'm going to give the mic to each of you now.
But before I answer that, I wish to share with you our challenge that because now we have more and more law journals created, now we have scarcity of peer reviewer. Yeah, so becoming a peer reviewer is a very demanding work. So this is one of the area that making the process a bit longer. But for Indonesian Journal of International Law, the author should expect between 6 to 1 year. That's for normal. Thank you.
Yeah. 6 months to 1 year. It's the same, 6 months to 10 or 1 year. Nevertheless, now it's already fixed until August 2026. I guess that's the benefit of being indexed in Scopus, that we are not running out the articles basically, except just looking at the best articles.
Yeah, I think for us will be the same, around 6 months until 1 year. But I don't know. But I'm having this feeling that the issues of publishing in journal these days is becoming like a business, right? We like it or not. I mean, a lot of journal monetize the whole process. And since we are under the law faculty, we are trying our best not to put out these APCs as far as we can. But what is also difficult for us is the tradition to give out some money, for instance, for those who act as a peer reviewer. Because the condition will be slightly different with peer reviewers abroad, lecturers abroad, who are quite already stable inside the university. But many of us in Indonesia, it's also struggling, not just in terms of timing and workload, but we still have other issues working at the university with so many obligations, and putting that aside, plus your obligation to review some articles. The quality of the reviewers can be different from one people to another, and what is also quite difficult to maintain is not only the quality of the manuscript itself, but also the quality of the reviewers. So managing a journal is indeed like a marathon. It's not as simple as we imagined in the beginning, but then, yeah, I think that some sort of cooperation is needed at the end of the day.
Thank you. So same question to you, Dr. Arif. How long does it take to be published onto your journal?
Yeah, so the timeline, I think, is broadly consistent with what you've heard, and the rate limiting steps or the challenge can indeed be peer reviewers. It is not unusual to have to send it out to, 5, 6 people to get 2 people that will agree, and sometimes the peer reviews come a little later than you want. The only additional thing I would say, and I don't know if this applies to the journals in Indonesia, the editors on the panel, but because we have gone to a fully online structure now, we do have something called first view publication. And the first view publication allows the piece to be published online before it is actually collected into a formal issue. So that allows the authors to kind of refer people to it because it is published in a date and they can refer to it. So that usually enables us to get something out maybe within a little bit more than a year. But to get in a formal issue, yeah, we're also kind of booking to now 2027.
Okay, thank you. And I'm still vested with authority to pick one more question from Bapak yang blue shirt. Yeah.
Hello, thank you for this time. My question is very simple. Why your journal is only tends to be a Scopus index? Why you don't focus Web of Science also? Okay, thank you.
Okay, so the question was about the indexing, yeah, because in Indonesian context, maybe I want to hear from the Singaporean perspective, whether Scopus journal is mandated or not to be for the lecturer to claim their timesheet, for instance, because it's Indonesia, it's a different reality. Please.
Yeah. So the short answer to your question is no, but let me give it a slightly more complicated answer, which is we have and it's certainly it applies at my law school and I think others in Singapore as well. We have a sort of gradation of journals. They've sort of been ranked. It's not just Scopus, which is our cutoff, but even within that, other gradations. And so really, if people want to advance and sort of promote themselves and get promotion, you have to try and publish in the highest ranked journals. For the Asian Journal of Comparative Law, in addition to Scopus, we are also working on getting indexed in the Social Sciences Citation Index, the SSCI. Right now, we are in the ESCI, which is Emerging Social Sciences Index, and we're looking to get into the SSCI. So we're trying to add other citation indices to our journal.
Thank you, and we're going to hear from the UI Law journals.
As far as my experience running the journal and in the faculty, I guess it is safe to say that we can focus one at a time. And being hard enough to be indexed in one database, that we can gain what we are needed. So along the time, if we have the opportunity to add another indexation, that probably needed another support from the faculty in terms of the human resources, financial resources, and so on and so forth. So I guess at this stage, we can safely to say it is enough for us, but then it doesn't mean that we are not keen to improve the journal. Thank you.
Right. Now, since already at noon in Jakarta time, so please give applause. We come to the end to our discussion. Thank you so much. This is very wonderful. And now I'm going to give the floor back to the Master of Ceremony, please.
Thank you so much to Mas Rizky Banyu Alam and all the panelists, Professor Ari, Mbak Patricia, and also Mbak Teresia. Thank you so much. And I would like to invite Dr. Gratianus Pika to come forward and present the tokens of appreciation to our panelists and also our moderator for the plenary session 2. Please stand up and we take a picture together. First, for Professor Ari Afriansyah. And also for the second, Dr. Patricia Rinwigati. Third, for Dr. Teresia Dia Wirasti. And finally, for our moderator, Rizky Banyu Alam. And I would invite all the speakers, moderator, and also Dr. Prika to remain on the center of the stage for a photo session. Thank you very much for all the panelists in our second plenary session. Thank you so much also, Dr. Prika. Ladies and gentlemen, that concludes the opening ceremony of the icLave Conference 2025. And once again, I would like to express our appreciation to all the distinguished speakers, moderator, and all the participants from the beginning until our end of the panel session plenary 2. We will now proceed to the lunch break and also followed by the panel session in this afternoon. But first of all, please kindly check the conference schedule for your panel room assignment. And we will also have our committee members who will guide you to the respective rooms. And they are already standing on the left and right side of the auditorium exit doors. Please take a look so you can familiar with all the handsome faces in here. Yeah? Before that, the lunch will be served at the Selasar area of the new building located just behind this auditorium. And I also want to remind to all the participants, all the panelists, for drop the materials and the presentation through the link that can be accessed here. Please scan the link to drop the presentation or the materials so our committee can help to assist and probably go onto the screens while you present your paper on the chamber. And also, please take care of the personal belongings and not to leave any items unattended before leaving the auditorium. And I also want to remind, after the planner session, We also have the gala dinner that will be held this evening in this auditorium. So I would like to see all the participants again in that gala dinner this afternoon. Thank you and welcome once again to the icLave Conference 2025 with the theme Disruption in Legal and Governance, Rethinking the Concept of Sustainability, Development and Democracy. See you at the gala dinner and please have a good break. Thank you so much. Nama saya Nini Primandiri, thank you.